We're joined today by San Francisco District Attorney Chesa Boudin, California State Assembly Member Phil Ting, and Uncommon Law Executive Director Keith Watley to talk about the California District Attorneys Association's opposition to critical justice reform. Now, the California District Attorneys Association, known as the CDAA, is a political organization of district attorneys in California that is proactively opposing justice reform. Despite weeks of protest due to an ongoing crisis of police killings of Black Americans, despite overcrowded jails, and several of the top 15 national hotspots for COVID-19 being California-based correctional facilities, the District Attorneys Association is working to keep people in cages. The association is working specifically to kill provisions in California Senate Bill 118 and Assembly Bill 88 that are aimed at allowing judges to grant misdemeanor diversion to eligible candidates and that would extend parole opportunities for elderly candidates. In other words, fewer people would go to jail and more people who are currently incarcerated would be diverted or released. Currently, district attorneys in some counties can grant misdemeanor diversion. The power is discretionary. This new legislation would extend this discretionary power to judges, but the CDAA doesn't want that. Now, for decades, California has had terribly overcrowded prisons. There are currently 114,000 people incarcerated in a system built for 89,000. 23% of those people are over the age of 50. 49.8% of people incarcerated are low risk for recidivism according to the CDCR's own risk assessment. But still, the CDAA is opposing the opportunity for parole for elderly people who've already served 20 years behind bars. And just for a little context, 1 year in prison in California costs taxpayers $81,000 per incarcerated person. Now, today's show will give us the opportunity to hear from 3 people about their dealings with the association and what people opposed to mass incarceration and overcriminalization should know about it. So let's start with a little bit about the association. And for that, we will turn first to District Attorney Chesa Boudin. Now, District Attorney Boudin, you joined the California District Attorneys Association after you were elected District Attorney of San Francisco. Can you tell us a little bit about what the association does and why you chose to join it?
Good afternoon, Summer. Great to be with you and the other panelists. Thanks for bringing us all together. To answer your question, the California District Attorney Association is an organization that represents approximately 3,000 prosecutors all across the state of California. It provides training, publications, and legislative advocacy. One of the main things that we're talking about today, and one of the main things that the association is known for, is its very influential lobbying in Sacramento around state legislation, and also the effect that the association has through impact litigation around strategic issues, either supporting changes in the law or opposing new legislation even after it's taken effect and been signed into law. Now, after I was elected as a district attorney of San Francisco, I wanted to get insight into what the association does. I wanted to understand how the association functions, and I wanted to be able to advocate for change from within.
Thank you. Now, District Attorney Boudin, how has your experience as a member of the association been? So what insights have you learned? And also, do you feel that there is a need for the carceral District Attorney Association to basically serve as a counterbalance to the current association?
It's definitely something I've thought a lot about, Summer. You know, over the years, historically, CDAA has taken an approach that is much more reflective of the status quo, of defending the policies and practices that have led to mass incarceration than of the values that I represent or that San Francisco elected me to advocate for. I've been very disappointed over the years with the specific policies CDAA has taken, both opposing progressive legislative reforms in Sacramento, and as I said, litigating against many of those new laws once they take effect, or interpreting them in ways that are so narrow as to be meaningless. And I can say that as with any organization, I believe often the best change comes from within. I'm fighting hard to help achieve that change from within the organization. And I think many of the elections that we're going to have in the next year or two around the state of California, including the Los Angeles District Attorney's race, may have a very significant impact on the direction that CDAA takes politically. But I also think it may well be time for a new organization, for a counterbalance, for a group of progressive decarceral prosecutors who can come together and be a powerful voice in Sacramento for common sense, data-driven criminal justice policies that put victims first, that put rehabilitation before punishment, and that recognize the fundamental dignity and humanity of every single person whose lives are impacted by crime or by the criminal justice system. I'm afraid that CDAA has often failed to do that, and the training role that it plays sadly contributes to a culture within prosecutors' offices that I think is part of the problem we see and that's leading to these protests and these uprisings all across the country, that has led to so much distrust between communities and our departments. And I think we need to start doing a better job holding ourselves accountable, holding police accountable, and really transforming the culture of what it means to be a prosecutor in California. I hope CDAA can catch up with the times. But I will tell you, for example, Summer, you mentioned the, I think it was Assembly Bill 118 and Senate Bill 88 that CDAA opposed. That was a position CDAA took without actually even consulting me, one of the 58 elected members of the association. I was disappointed to see that the association took that position. And I was disappointed more so that it took that position on behalf of all of its members without even consulting me or I imagine many of the other members. So there's definitely need for change, and I'm excited to be part of that change or look elsewhere if the association won't catch up with the times.
Thank you. And yes, there is clearly a need for change. And just like you said, District Attorney Boudin, just centering and focusing on the common humanity of every person who is touched by the criminal justice system is so important. Now, moving the conversation to San Francisco, how do you think your jurisdiction of San Francisco has handled justice reform relative to other counties across the state? And how has that played into what's happened with pandemic hotspots or the national protest and these calls for racial equality?
San Francisco has, in the space of criminal justice reform, as in so many other spaces, been ahead of the curve at the state level and nationally. San Francisco's leading the charge in ending money bail. I was proud that one of the very first policies I implemented when I took office in January was a policy prohibiting my staff from seeking money bail. I was also proud to expand diversion opportunities my first week in office. I helped implement in the first county in the state to implement a new diversion policy that recognizes the fundamental role that parents and primary caregivers play in keeping their families and communities safe, and puts their ability to be parents and caregivers before the need for criminal convictions or incarceration. I think those kinds of changes, even before COVID-19 hit, helped us prepare for the real consequences, severe consequences of this pandemic. I'm proud to say that San Francisco has reduced its jail population by over 40%. And we did that in part by relying on alternatives to incarceration, diversion programs, non-carceral supervision, and many of the things that other jurisdictions around the state and the country were too slow to do. And we've seen the horrific consequences. We're dealing now with a massive outbreak in San Quentin prison. We saw Rikers Island in New York, Cook County Jail in Chicago, Marion Prison in Ohio, and most of the major hotspots for transmission have been jails or prisons across the country. We saw that. We listened to the advice of our medical experts, our medical director of the county jail, and we took steps to protect not just the people who are incarcerated, but all of those who work in the jail, the sheriff's deputies, the court staff, the public defenders, the staff in my office. We recognize that in a country that is as addicted to incarceration as the United States, all of us in some way are directly connected to a jail or a prison. And in order to keep all of us safe, we need to start aggressively decarcerating and exploring alternatives. In the context of the uprisings, responding to George Floyd's murder, we've also been ahead of the curve in San Francisco. Our office has taken significant steps to minimize or avoid conflicts between the district attorney's office and the police department. So, for example, I took a pledge together with two other elected district attorneys and a formerly elected district attorney to never accept donations directly from police unions and to never seek police unions' endorsements in a race for district attorney. We've urged the other members of CDAA to join us in that pledge, but so far, none have been willing to join us. We also introduced a resolution that would prevent San Francisco from hiring police officers or sheriff's deputies who have a history of serious misconduct in another jurisdiction. We don't want to put bad apples on our streets. We don't want to be a safe haven for police officers who've committed egregious misconduct elsewhere. We want to increase the standard that we require of anyone we give a uniform and a badge and a gun to in the city of San Francisco. We also have taken other steps. For example, we've required our assistant district attorneys to review body-worn camera footage before filing any case involving charges of resisting arrest or assault on an officer. Of course, we take those kinds of crimes very seriously and we will continue to prosecute them. But we also know, as happened in George Floyd's case, that when officers use excessive force, all too often, the written police report reads as though they were responding to someone resisting arrest or assaulting them. And we can't help but be complicit in covering up police misconduct if we're unwilling to look at the evidence and review the footage before we file charges. So that's now a requirement in all of our cases. We've also taken additional steps, such as making sure that we don't have anyone from San Francisco on death row. I'm excited to say there's only one person dating back decades from San Francisco who is on death row, and we're taking steps to get that person off of death row. We need to lead the country, and we can't do it if we don't look at home and clean up our own house first. So we've been going to great lengths in San Francisco to implement best practices to prevent conflicts of interest, to hold police accountable, and to make sure that we're promoting public safety through a victims first, healing, and rehabilitation paradigm rather than a punitive lock them up and throw away the key paradigm.
Thank you, District Attorney Boudin, for everything you're doing to promote progressive policies in San Francisco and to push for positive change within the CDAA, because like you said, it's time for all of us to clean house. So moving next to Assemblymember Ting. Assemblymember Ting, I want to ask you about each of these bills. So first, giving judges the discretion in the appropriate case to let someone accused of a misdemeanor get diverted out of the criminal justice system. Now, this seems like low-hanging fruit. This is not a radical idea by any means, and yet the CDAA has strongly opposed letting judges do this. Why do you think that is, and what do you think about their stance?
I think that's a great question, Summer. I think, unfortunately, what we've seen is CDAA and unfortunately many law enforcement agencies have really, for the last number of years, really been against all the various different reform proposals that we have been pushing forward. It's been unfortunate because I think we've been trying to have a discussion in Sacramento about ways that we could really reform the way that we do public safety. I think we've made a significant amount of progress in terms of reducing incarceration. And in fact, within these bills were a huge step to actually close 2 state prisons in the next 3 years, which is something that I know many of us have been asking for, because at this point, our corrections budget is almost as much as our higher education budget. In terms of judicial discretion, you're absolutely right. It seems that DAs currently have this discretion to provide misdemeanor diversion. It just made sense that judges could also have that. It didn't mandate anything. It just gave judges the same discretions that the DAs have.
Thank you, Assembly Member. So now moving on to the second bill. Now, the second bill would allow people who are currently over the age of 50 and who have already served 20 years of a sentence to simply go before the parole board. It doesn't give anyone a get out of jail free card. They would simply be allowed to make their case before parole board that they should be allowed to be released to community supervision. Again, this does not seem radical, and yet the CDAA is working to keep people who are elderly and who have already spent decades of their lives behind bars in California's notoriously overcrowded prisons. So how is the California District Attorneys Association working to stop this bill's passage?
Well, again, they typically when people oppose bills, they send out alerts, they send out emails, they may contact individual legislators directly. To me, it wasn't clear exactly what they did, but they definitely created quite an impression. And let me just go back for a second. We talked about the corrections budget, and you mentioned it's about $80,000 per individual to incarcerate somebody. We spend upwards of $13+ billion in our corrections system. But for people who are elderly, it could cost as much as $300,000 per person. And the reason it's so expensive is because the healthcare costs are very high. If they were not in prison, the state wouldn't pay for their healthcare coverage. They would be on Medicare. And so there would actually be a huge reduction in terms of cost for the state. The other part is for elderly inmates who need a significant amount of healthcare, they don't really pose much of a threat because they are in need of such care. And so this made a significant amount of sense to take a hard look and say, hey, why wouldn't we do elderly parole, make sure that the people who are the sickest need medical care? Why do we have to provide them the medical care within a prison system? Why couldn't we just do that in a traditional healthcare system and also move their costs off the state books and put them onto Medicare, which is what other seniors who need healthcare cost. So again, this made the most sense in terms of a budget proposal, but unfortunately, CDAA and many other agencies came out in opposition. And unfortunately, because the opposition came rather quickly, we were not able to respond. Now that we've had a little bit more time to respond, we're hopefully going to be able to take a not harder look at this proposal in ways that we could sort of continue to get those cost savings by ensuring that people who are elderly and need healthcare can get that healthcare outside of the prison system.
Thank you, Assembly Member, and hopefully you can still hear. I think there's a gardener outside my door, but I just kind of want to move a little bit into your history working for prison reform. And you could tell just by your last response how informed you are and how much you've been working to really address mass incarceration in our state. So you've been involved for years in trying to reduce California's prison population. Is this the first time that the DA Association has stepped in to stop a reform bill that would help to reduce the amount of people who are in prison?
Unfortunately, they haven't, and I don't know that they won't continue, unfortunately. You have a system that is very focused on incarceration. And so you have a group of individuals, and the way they get judged is how successful they are at prosecuting and convicting individuals. That shouldn't be the barometer we have as a society. The societal barometer should be how safe are we? What is the level of expectation regarding public safety? And obviously, by prosecuting certain people or reforming certain people, are we really better off? And so I think the hope is that we can take a much harder look at moving people away from these false statistics and really focused on whether or not we are safe. It seems ironic at a time when you have different agencies whipping up people into a frenzy when we have an all-time low in terms of the crime rate. We have some of the lowest crime rate we've seen in decades, and yet people at times feel very concerned about what crimes may or may not occur. So I think we really need to, again, go back and look at the data. Unfortunately, regarding public safety, very often it's not a data-driven conversation. It's a very emotional conversation. So I think we do need to ensure that we are taking a look at the evidence and the research and the best practices rather than being so focused on just people's individual emotions.
Thank you, Assemblymember Ting. And a focus on best practices is what we need right now.
Absolutely.
So moving to Keith Watley. Now, Keith, can you start off by telling us about what uncommon law does?
Thanks, Summer. Thanks for having me, and thanks for this important conversation. You have to think about it this way, or we choose to think about it this way. If a person acts in a way that endangers others, and even if you thought that prison was the way to reduce their risk, a lot of disagreement about that, about whether prison is the way, but even if you thought that prison is the way to reduce their risk, wouldn't most people agree that the person should be released as soon as that risk subsides? At our office, we work on really people's capacity to change from who they were, how they were at the time they committed serious and violent crimes. Most of our cases, that involves helping them to understand the ways in which their own trauma histories contributed to their actions and hurting others. Almost everyone who is in prison for a violent crime was a survivor of violence first. That's something that's lost, but it's the overwhelming majority. And once they've done that work to understand how their trauma histories contributed to their actions, we represent them before the parole board and help them come home from their life sentences. Almost all of our clients are serving life sentences with the possibility of parole. So if they do this work, they get to come home to their communities. And most of what we do is we're helping them tell their stories in a way that reflects their emotional intelligence and their own dramatic transformation. So it's really, it's unfortunate that we don't have someone on the show today who's gone through the process of having to convince a parole board to release them from prison after a serious crime. You know, I reached out to a former client about the show, and he was very interested in helping. He's someone who served 32 years in prison. And he was thinking of joining us, but when he found out it was the DA's association that was opposed to these bills, he was concerned. He was afraid. He was thinking that because they were the prosecutors, that they would try to attack him in some way, that they would try to revisit the facts of his crime as if they're relevant 32 years later, because they have demonstrated themselves, in my experience, as being unwilling to look past the details of the crime and see who the person is today.
Thank you, Keith, and thank you for giving us the perspective about your client and what his feelings are. As a former public defender, I completely understand clients having a hesitance and a fear of collateral consequences of challenging what's happening in the DA's office. You know, even if they're challenging something that shouldn't be happening, they fear that there's going to be some sort of negative blowback on them. And it's so difficult because it has a silencing effect on all of us and on people who need to be out there telling their stories. So you mentioned parole and the fact that uncommon law represents people at their parole hearings. Yeah, so can you talk to us about what the current parole grant rate is in California?
Well, it's important to understand really the scope of this situation. We have in California 35,000 people serving life sentences. 35,000. And there are several thousand more whose release from prison is still dependent on the parole board because either they were especially young at the time of their crimes or because they're older now. You know, the current laws age 60 and older, they've served 25 years. And there are a few other categories of people who could be released early if the parole board thinks it's safe to do so. But for all of these categories, anyone going to the parole board, only about 20% of the people who are eligible for parole each year are actually granted. And that's true of several of the new categories of people who get to go to the parole board to be considered. Most are not granted in that year that they're being considered. Still only about 20% are granted.
So 20% is a very low number, and I think lower than most of our viewers would expect to hear. And that's why it is so imperative that bills like the ones that have been proposed are pushed forward. So can you explain why a bill that increases opportunities for elderly parole is so critical right now?
Well, if you consider the reason that elder parole or elder parole consideration is even a thing, it's because California's system is finally starting to catch up with all the research that has long taught us that people age out of crime, especially violent crime. Under the current law, the parole board has to give special consideration to how a person has changed, how they've changed physically, psychologically, emotionally, in their associations, and especially in their impulsivity, their compassion, their overall decision making. And those factors are supposed to be given special consideration when contrasted with how they were at the time of their crimes decades earlier. The idea is we have a law that on its face recognizes that people who are over age 50, especially age 60 as the current law, are at a dramatically reduced risk of any future crime, much less a violent crime. The current cutoff of 60 is frankly always been out of step with the science and the research telling us that people above 50 really pose very little risk. So it's time to fix that, I think. Another thing that it's important, and you mentioned it in your introduction, that we're talking about 20% of California's prison population being over age 50. So you could potentially release more than 20,000 people from this system and see no increased risk to public safety.
Now, Keith, has the District Attorneys Association done anything, in your opinion or in your experience, to improve the likelihood of successful reentry of people who are leaving custody, or to reduce the cycle of over-policing and mass incarceration in California?
Well, in my experience, it's quite the opposite. I've seen district attorney representatives be completely unwilling to acknowledge how much someone has changed. And I've seen them discount a person's current physical or mental condition to instead focus on the crime they committed a lifetime ago. I've been in hundreds of parole hearings, and I don't even need all the fingers on one hand to count the number of times a DA has expressed support for someone's parole. That's how infrequently that happens. Sometimes the most we hope for is that they don't take an official position. They just defer to the parole board's discretion. But almost all the time, they're there to oppose parole, and they focus on the most minute, irrelevant things that have no bearing on, no connection to, no correlation to public safety risk, to be the basis for denying parole. And as I said, most people who are eligible for parole each year are denied. So up to now, the DA's positions do seem to be, carrying some weight when it comes to the parole commissioner's decisions. We are seeing some improvements there, but we got a long way to go. And some of that is about the role that the DAs are playing, that they should be playing relative to people who've come from their counties, from their communities, and they should be invested in having them safely come home. We don't see nearly enough of that.
Thank you, Keith, because there definitely has to be an investment in having people come home safely, because that's where most people are going to go. It's important to support our family members, our community members who are reentering their communities. Now, at this point, I'd just like to open up one question to the entire panel, and I would just love to hear your thoughts on this one. So a report from the Justice Collaborative Institute with Data for Progress found substantial support for actions that would reduce the incarcerated population in California. 6 out of 10 California voters want measures that could get vulnerable populations like elderly people out of jail in light of the pandemic. These bills seem to accomplish these goals. But why is there a disconnect between popular support and implemented policy? And what more can be done to pressure electeds into making the changes that most voters want? So, District Attorney Boudin, can you start us off with this question?
Absolutely, Summer. And it's a really important question. I think in some ways, the comments that Assemblymember Tang and that Keith made earlier speak to this issue. And I want to just emphasize a couple things that they said. Assemblymember Tang pointed out that all too often, district attorneys feel pressure to evaluate their success based on conviction rates or length of sentences and that kind of culture, rather than looking at data. And that, as he described, there's often an emotional response that leads criminal justice policy rather than a data-driven approach. And so I think part of it is just recognizing that tragic crimes can and will occur. The fact that we accept and recognize that reality doesn't mean we don't care about them. It doesn't mean that we're not taking measures to reduce and prevent them. We should be evaluated as elected district attorneys based on the policies that we put in place, based on the steps that we take to enhance justice, to promote public safety as broadly defined, not simply based on our response to the most high-profile outlier crime that occurs during our tenure. And it's a challenge because the media often, for understandable reasons, is going to cover and sensationalize those high-profile offenses. And they're going to demand that the district attorney's response to those individual cases be draconian, rather than taking a step back and saying, what can we do? What policies can we put in place that in the long term promote public safety and use our resources efficiently? So to give two very concrete examples, we know empirically that diversion helps reduce serious crime, that engaging upfront with low-level offenders in a way that gives them services and support and protects them against or gives them a pathway to avoid having a permanent criminal record helps promote public safety, helps people get jobs, helps people stay out of poverty. And yet, there's very little criminal justice media coverage of diversion programs or their success. So same thing with the work that Keith was describing. My mother spent 22 years in prison. And when she went to the parole board in New York State, the parole board was not interested in the fact that she had done tremendous amounts of amazing programming in prison. They weren't interested in the fact that she had been a model prisoner and helped save lives through her AIDS education work while incarcerated. They were looking at the severity of the crime. They were looking at the fact that this, the police unions and the district attorneys associations in New York were opposed to her release. And that's what motivated them to reject her when she first went to the parole board and when she went back to the parole board a second time. We need to start looking at data and public safety, and we need to recognize that people in their 50s present virtually no risk of violent crime, and that we are far better off as a society, more humane, more efficient use of tax dollars, if we take that money and we invest it in reentry programming, if we invested in crime prevention and education. As Assemblymember Ting said, we need to start putting our money into things that we know make us stronger and safer, like higher education. And until voters demand that and hold elected officials accountable to that, until we get more media outlets covering the quiet but transformative success stories when we end money bail, or when we promote diversion, or when we allow someone who's in their 50s or 60s to come home to their community, it's going to be very hard to achieve the kind of cultural transformations within CDAA and the individual district attorney's offices across the state that are necessary to move the country forward.
Thank you, District Attorney Boudin. Now, Keith or Assemblymember Ting, do you have anything that you'd like to add?
The only thing I would add, Summer, is that you have this disconnect quite often because of fear. And many times people are being judged by the crime they committed often decades previously. And when people hear that crime, they are judging that person when that person may be a much younger individual than the person that they are today that should be getting paroled. And so you have this disconnect where you have this crime that was committed years ago, and this individual that was, that committed this crime years ago, not being judged against the person who is standing before the parole board or standing before the voters today. And I think that's one of the biggest challenges, is that particular crime, once you hear it, it sounds very bad. And so people don't really want to give that person a second chance, even though there may be a significant amount of evidence over the decades that they've served in prison that they should be given that second chance. The other part that the district attorney mentioned is very rarely do people go to prison and actually get better. We have this rehabilitation part in our correction system, but very rarely do you feel like that rehabilitation is actually working, and that people go to prison and they actually come out better, which is actually what happens in other countries. And so why not, if we want a safer society, why wouldn't we put them someplace where they could get better and actually become more productive and not become somebody who we are afraid of putting back on the street? So again, I think those are some of the reasons why we have this disconnect.
Thank you,
Yeah, I would-
Assemblymember Ting. Please.
I
go
would just
ahead.
add that you have I think you're absolutely right, Assemblymember Ting, to point out the fear factor, but we also have a decades-long commitment to just a punitive response to trauma, right? We try to punish everything, find a way to criminalize and punish everything, even though this punitive response that has blown up our prisons doesn't actually make anybody safe. It doesn't, and it certainly doesn't help anybody heal from the trauma. The survivors of even violent crime. And as I indicated, the people who are in prison for violent crimes are survivors of violent crime. We have a lack of imagination about how to deal with the earlier trauma, like the original trauma. So if we had a regular practice within our communities, when someone's parent goes to prison, or when parents are divorced, or a parent passes away, or just gets arrested, or there's an incident of domestic violence, if we committed the resource in the form of a social worker or a counselor for those kids, they wouldn't be my client in 20 years, because they'd have a new way to understand how that trauma impacts them, what it means about them or doesn't mean about them. And they've developed coping strategies that don't look like they're trying to make up for feeling inadequate or just not enough, and choosing patterns that may hurt themselves and may hurt other people. That's what it looks like. But we haven't focused on the front end like that. We find a way to punish the kid who's acting out in school. We send school resource officers to ultimately lock them up, to send them to prison in a couple of years. We need to reimagine that whole system. And I don't mean reform. We need to replace it with something completely different.
Thank you. Thank you to all of our panelists. And thank you all again for joining us for this important conversation. We'll see you again tomorrow on the briefing for the Maricopa County Attorney Candidate Forum, which will be at 2 p.m. Eastern, 11 a.m. Pacific. And we hope you all have a safe and pleasant